what Netlaw is Netlaw is an IT company that was created out of an estate planning law office in Louisville, Kentucky. And the reason that we created our sub company, Netlaw, from the law office was back in 2012, we read in a Bloomberg report that said that over 60% of Americans don't have a will. And that's a scary number, right? Because we all know the importance of having our wills and our trusts taken care of. So we went ahead and we designed, for those who didn't want to come into our law office, we created a software created by attorneys. So if you use this software, you have the ability to create your estate planning documents online in the convenience of your home. Not only complete your documents, but go back and edit them at any time for one low cost. Netlaw doesn't charge any kind of monthly fees, yearly fees, reinstatement fees, anything like that. You pay a one-time fee, and then you can get started with Netlaw and have the ability, again, to create all of these documents and go back and edit them at any time. But let's talk about really a full comprehensive plan. You know, a lot of people say, well, what if I just get my will? Am I covered? Well, we'll talk about that. But really, we think from the law perspective, you need all of these documents to have a full comprehensive plan set up for you and your spouse. And as you can read through these, you know, there's 7 documents here that you could possibly partake in. The great thing is one plan covers both spouses. So both spouses get to create their full set of documents using our Netlaw software. And again, the Netlaw software is created 100% by attorneys in your state. So you are creating state-specific legal documents from an attorney. So as we go through these documents, we'll talk about why they're so important and then what happens if, you know, something happens and we don't have these documents, right? But, you know, when we think about estate planning, you know, will and trust always comes up first. And, you know, the reason that the will is so important is because, to me, the will is our listing document. We're going to list everything in our will. We're going to list executors. Those are the people who are going to handle everything after we pass away. The great thing is you get to name a main executor, and then you get to name alternate executors as well. In case the first person's unable to do it, you always have backups, right? So your executor is going to be responsible for making sure that all of your assets get to your beneficiaries. They're going to make sure that all of your bills are paid, all of your creditors are paid, your taxes are filed. They're going to handle everything. So I always get the question, can my executor be someone from overseas? Well, they could. You could list someone from overseas, but that main person usually needs to be someone from your state because they are going to act right away. Again, if you don't have anyone from the US that you want to put in there, of course, name someone from overseas. But most states recommend highly that that first person is someone from the US. The second reason you do your will, you get to list guardians. So if you are a parent of an underage child or children, if something happens to you and your spouse, who's going to take care of your kids, right? So we need to make sure that we have our guardians listed as well. And again, those have to be over the age of 18. And again, you get to list a main guardian and alternate guardians as well. And the last reason for our will is we call it specific bequest, but this is listing all of our assets and who those beneficiaries are. Who's going to receive all of our stuff, right? So it's very, very important that we make sure that we list all of our major assets and who those beneficiaries are. Now, the second line item is included in the will as well. It's a children's trust. And sometimes it's called a descendants trust, but what that simply is where you can go in and list at what age and what percentage of your child's inheritance they will receive if you and your spouse pass away before they're 18. So if you do nothing, they will receive everything at age 18. But a lot of parents go, yeah, they're 18, but still way too young to be receiving this amount of influx of assets, cash, right? So you have the ability to spread their inheritance out over time using our children's trust. Third line item is our financial power of attorney. This is where we get to name someone who can make all of our financial decisions for us if we're not able to. whether we're sick, we're in the hospital, or it could be that we are out of town, right? You go back to India for a month on vacation. Something happens here. Hey, don't worry about it. Let your power of attorney handle everything. You don't have to rush back. So having that person who can make our financial responsibilities for us if we can't do it for ourselves, or maybe we're incapacitated. You know, you think about maybe our parents, right? Our parents, they're getting up into the golden age. Maybe their minds aren't as sharp. Might be a good idea for you to set up a power of attorney for them as well, so that if anything happens, you as the kids can go in and take care of that as well. So the next three documents are our healthcare documents. Netlaw gives you a full comprehensive plan that protects your financial decisions and your healthcare decisions. Your healthcare surrogate is your medical POA, who's going to speak to the doctors and nurses on your behalf, making sure that everyone understands what needs to happen and when. Your HIPAA authorization is that person who gets to see your medical charts. Your HIPAA authorization agent and your healthcare surrogate, usually the same person because they do almost the same exact thing. But again, your HIPAA authorization allows someone to see your medical charts. And the last healthcare document is your advance directives. And those are your end of life decisions. What do you want to happen at end of life? Do you want to be hooked up to a machine? Do you not? Do you want to give any body parts to science when you pass? Do you not? All of these decisions are up to you. We want to make sure that you make these decisions and not anyone else. We even have a pet trust. So if you're a pet lover, great. You can leave money behind in a trust for the well-being and the care of your animals. And then the last document goes right along with your will, the revocable living trust. This is our probate avoidance trust. And let's talk about what probate is first and why we want to avoid it. So probate is the process where if you pass away and you don't have your assets transferred into the ownership of the trust, all of your assets are frozen by the government when you pass away. And what that does is it allows time for creditors to come in and file a claim on your estate. Now, every state has a time period for the creditors to do this. Usually it's anywhere from 6 months to a year. So in Kentucky, where I'm at, it's 6 months. If I passed away without a trust, my assets will be frozen for 6 months automatically. Now, I'm talking about individually owned assets. Joint assets that I share with my spouse, of course, that would be his or hers, right? Because they're still alive. But I'm talking about individually owned assets. Those would be frozen so that creditors have time to come in and file a claim on your estate. Those creditors have to be paid first, then everything gets passed. But this is a probate avoidance trust. You have the ability to put your U.S. properties, international properties, LLCs, I don't know, rental properties, right? Any of our major assets, we can transfer those out of our individual names and into the name of the trust. That way, when we pass away, these assets avoid the probate court and get passed to our beneficiaries right away. We even have a funding instruction sheet that walks you through how to do all of this. Very, very easy to do and very necessary. I always get the question, should I do a will or should I do a trust? For me, it's both, right? Because they do two totally different things. Your will, like I said, is your listing document. We're listing our executors, our guardians. We're listing our assets and who those beneficiaries are. In the trust, we're transferring ownership from our individual name to our trust name. Now remember, you're the trustee of your account for as long as you're alive. So you don't lose any authority or power. You can sell your house at any time, add new properties into your trust at any time. But making sure that we have the ability when we pass, that everything is taken care of and nothing gets held up in probate court. And we even have a 7-day money back guarantee. As long as you haven't downloaded any of your documents, we'll give you your money back. No questions asked. And I always get the question, well, Mark, what happens if I don't do these? What's the worst that can happen? Well, a lot. So if you don't create this and you have children under the age of 18, Did you know that a judge will come in and decide who gets custody of your kids? If both parents pass away and there's children under the age of 18, a judge will decide who gets custody of your kids. Not only custody, but that person will be in control of their inheritance until they turn 18. Now, there's 38 of us on this call. I can almost guarantee that all 38 of us don't want a judge making that decision, right? We know who's best to raise our kids. That's why this is so important. And we're going to list all of our assets in that will and who those beneficiaries are. If we don't do that, the government will decide for us how our assets are distributed. In Kentucky, if I pass away without a will, all of my individually owned assets again will go through probate. Plus, they will be distributed at 50% to my spouse, 50% directly to my kids right away. That's not how I want my assets distributed, right? So we are creating this so that we stay in control of everything that needs to happen, right? If we get sick, if we're out of the country, we need that power of attorney. If not, who's going to take care of everything? And what happens if we pass away without the trust? Those assets will sit there in trust for a minimum of 6 months, up to a year. Our beneficiaries can't grab those assets because they're frozen. But if we transfer them out of our name and into the name of your revocable living trust, they can gain access to those accounts right away. That's why all of these documents are so important. Making sure that everything is taken care of here. And Netlaw doesn't sell each of these documents individually like other companies. We sell this as one complete package because you need the full complete package. And once you pay for this plan, you don't have to pay anything else. You have unlimited access to create and edit your documents at any time. And the last thing about Netlaw, before I show you the demo of the software, is Netlaw is the only law firm to win the James Keene Award from the American Bar Association. So the American Bar Association awarded Netlaw the James Keene Award for the best online delivery of legal documents. And I'll say that again because it's important. The best online delivery of legal documents. That was awarded to the Hargrove firm for Netlaw. That's what separates us from everyone else. No monthly fees. And we won the James Keene Award from the American Bar Association. So let me